Hey, welcome to True Grit Crime. I'm your host, Mel Gritty. I'm finally coming back to go ahead and read the verified motion to correct errors, just to get it on the record or whatever. So that's what we're doing here. And then I'm just going to kind of have some thoughts, I guess, maybe along the way as I'm going here. So, comes now the defendant, Richard Allen, by counsel and files his verified motion to correct errors. For the reason that follows, the court should either vacate Mr. Allen's convictions or set the matters set out. My gosh. Okay. The court should either vacate Mr. Allen's convictions or set the matters set out below for hearing. Number one, in violation of the 6th and 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping proceedings of November 3rd, 2022. That proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel. And under the United States versus Chronic 466 U.S. 68, 1984, and its progeny, the court must presume Mr. Allen was prejudiced by being unrepresented during that proceeding. Indiana Code 3533.11.1 governs safekeeping proceedings for pretrial detainees and provides in full 3533.11 transfers for personal safety or safety of others upon motion by the sheriff, prosecuting attorney, defendant or his counsel, attorney general, or the court. Alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death or represents a substantial threat to the safety of others. The court shall determine whether the inmate is in imminent danger of serious bodily injury or death or represents a substantial threat to the safety of others. If the court finds the inmate is in danger of serious bodily injury or death or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county or to a facility of the Department of Corrections designated by the commissioner of the department of suitable for the confinement of that prisoner and provided that space is available. For the purpose of this chapter, an inmate is not considered in danger of serious bodily injury or due death to an illness or other medical conditions. Indiana Code 3533.11.2 also governs safekeeping proceedings for pretrial detainees and provides in full 3533.11.2 post-transfer hearing, right of inmate to refuse a transfer hearing. The inmate or receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse transfer if the only issue is his personal safety. Mr. Allen was interrogated and arrested on October 26, 2022, and booked into the Carroll County Jail under a pseudonym. The next day, October 27th, 2022, Kathy Allen, Mr. Allen's wife, hired an attorney, Brett Gibson, to represent Mr. Allen. Exhibit 1, which is an affidavit of Kathy Allen, and I'm not going to pull up a separate exhibit right now. I'll do that next. In the event of the October 27th, Mr. Gibson sent a letter by email to the Carroll County Sheriff's Office and to Nicholas McLeland, the Carroll County prosecutor. What emerges from the defendant's exhibits 1C and 1D is the following. Sheriff Lesenby confirmed receipt of Mr. Gibson's letter by telephone the evening of the October 27th. Also on October 27th, however, over the telephone, someone at the Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. Mr. Gibson then contacted Mr. McLeland by email, after which Mr. McLeland called Mr. Gibson on his cell phone. Mr. McLeland told Mr. Gibson that Mr. Allen was listed at the jail under a different name or alias, but arranged for Mr. Gibson to meet with Mr. Allen. Mr. Gibson went to the Carroll County Jail, where someone from the sheriff's office took Mr. Gibson to a meeting room. It appeared to Mr. Gibson The regular jail staff did not know Mr. Allen was there. Still, on the evening of October 27th, Mr. Gibson met with Mr. Allen and advised him not to discuss the case over the phone because calls would certainly be recorded. About 10 p.m. on October 27th, 2022, Mr. Gibson called Mrs. Allen to say that he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of murder the next day. On October 28th, 2022, without Mr. Gibson present, even though Mr. McLeland and Sheriff Lesenby both knew Mr. Allen was represented by Mr. Gibson, Mr. Allen was charged with 2 counts of murder, and Judge Diener held Mr. Allen's initial hearing. Shortly after his initial hearing on October 28th, Mr. Allen was whisked away from the Carroll County Jail to the White County Jail without a safekeeping order authorizing the transfer. And on November 1st, 2022, a letter from Mr. Allen was mailed from the White County Jail to the Carroll Circuit Court. The letter and the envelope are part of the record in this case, and in that letter, Mr. Allen requested that the court appoint counsel for him. Nothing in that letter indicated that he was not already represented. For some reason, although it had sufficient postage and was correctly addressed to the Carroll County Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to the White County Jail. It was then remailed from there and is shown filed in his court on November 9th, 2022. That was an error. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the courts as of November 1st, 2022, the day his letter was mailed from White County Jail. The prison mailbox rule, recognized by the United States Supreme Court in Houston versus Lack, 487 U.S. 266, 276, 1998, provides that pro se filings from an incarcerated litigant are considered filed at the time that they are delivered to the prison authorities for forwarding to the court. Lawrence versus State 915 NE 2D 202 205 Indiana Circuit Court of Appeals 2009, the safekeeping proceeding was plainly illegal from start to finish. Sheriff Lesenby transferred Mr. Allen to the White County Jail on October 28, 2022, with no safekeeping order in place. The next sheriff, Lesenby, had no standing to make the safekeeping order request on November 3rd, 2022, due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28, 2022. Once Mr. Allen was in the White County Jail, the White County Sheriff was the sheriff statutorily authorized to make a safekeeping request under Indiana Code 3533-11-1 because Sheriff Lesenby had no standing to make the safekeeping request. Judge Diener had no jurisdiction to consider it. Gloss versus City of Indianapolis 553 NE 2D 1204 1206 Indiana 1990, because Judge Diener had no jurisdiction to issue it, the safekeeping order would literally void TD versus State 219 and E3D 719 726 Indiana 2023. A judgment is void if it grants rights or relief to a party that does not have standing to pursue the action. Second, Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue a safekeeping order at Lesenby's request. That is because Judge Diener had engaged in ex parte communications with Sheriff Lesenby, helping Sheriff Lesenby draft his safekeeping request in violation of Rule 3.10 of the Code of Judicial Conduct. June 15, 2023, hearing page 11, Rule 310 prohibits judges from drafting or reviewing documents except for family members. Judge Diener also violated Rule 2.9, the code by engaging in substantive ex parte communications with Lesenby, which helping Lesenby draft the safekeeping order certainly were. Having violated both Rules 310 and 2.9, Judge Diener was obligated under Rule 2.11 of the code to recuse himself and request appointment of a special judge before he issued the safekeeping order, not after, which is what he did on November 3rd. Bell versus State, 695, NE 2D 129, 131 through 132, Indiana Court of Appeals, 1995, citing inter alia. Tyson versus State, 622, NE 2D 457, 459 through 460, Indiana, 1995, Shepard, CJ, recusal opinion. See also Rule 2.11 of the code. Comment 2. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Third, Sheriff Lesenby, November 3rd, 2022, request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the sheriff to the custody of the Indiana Department of Corrections for safekeeping was not served on anyone. There is no certificate of service attached. Indiana Code 3533-11-1 requires a safekeeping request be made by motion. Indiana Trial Rules 5A, 2, and 3 required that Sheriff Lesenby's motion for a safekeeping order be served on the parties. Because Sheriff Lesenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for the safekeeping order. Even if he claimed Mr. Gibson was not representing Mr. Allen at the time, Sheriff Lesenby was required to then serve Mr. Allen personally. Fourth, Sheriff Lesenby's safekeeping request was not verified. There was literally no evidence before Judge Diener from which he could make any factual findings requiring Indiana Code 35-33-11-1 that would authorize a safekeeping order. Fifth, because the factual finding was required to authorize the safekeeping order, a hearing with no notice to the parties on the Sheriff Lesenby's safekeeping request was required. Sixth, and perhaps most importantly, Mr. Allen had an absolute right to refuse being transferred to the custody of the Department of the Sheriff's, to the custody of the Department of Corrections. Sheriff Lesenby's safekeeping request allegedly no statutorily unauthorized basis for a safekeeping order other than a concern for Mr. Allen's personal safety. If the reason for a safekeeping transfer is only a defendant's personal safety, a defendant may refuse the transfer. Mr. Allen had no opportunity to exercise his right to refuse the transfer to the Indiana Department of Corrections custody or to make any objections to set out above the entire course of the proceeding. That is for a quite simple reason. Mr. Allen either personally, through his lawyer, Mr. Gibson, had no legal notice, skullduggery, that would land him in solitary confinement at the Westville Control Unit, Wabash Valley Control Facility, and Cass County for 23 months pending trial. Because Mr. Allen had no notice of what was afoot, neither he nor his lawyer could make any of the arrangements that would have necessarily prevented Mr. Allen's transfer. Finally, Mr. Allen's own absence. Mr. Allen's own absence from the safekeeping proceedings should be treated no differently from the absence of a lawyer to represent him. Indiana courts hold pro se litigants to the same standards trained lawyers, e.g., Zavodnik versus Harper, 17 NE 3D 259 266, Indiana Department, 2014. One consequence of this should be that the Sixth Amendment and Article 1 of the Indiana Constitution should apply to the pro se litigant and is excluded from proceeding at which he or she has the right to be present and participate in. Hi guys, welcome in. Sorry, I'm not looking at chat like on the main screen because I'm on the other screen, but Thank you for coming to listen. Welcome in. I'm going to keep going, and then we have a little bit of a conversation to have after this. So pro se litigant is excluded from a proceeding at which he or she has the right to be present and participate in. So it is a violation of the Sixth Amendment to completely deprive a defendant of counsel at any critical stage of the criminal prosecution. The safekeeping proceeding, such as it was a critical stage at which Mr. Allen had a Sixth Amendment right to have his lawyer interpose all of the objections to the November 3rd safekeeping order that was set out above. A critical stage is holding significant consequence for the accused. So according to Woods versus Donald, 575 U.S. 312, 315, 215, because Mr. Allen was entirely and unconstitutionally deprived of counsel at the safekeeping proceeding, the court must presume that Mr. Allen was prejudiced by that deprivation of counsel. Chronic 466 U.S. at 659, according to Garza versus Idaho, 586 U.S. 232, 237, 2019. So alternatively, Article 1 of the Indiana Constitution provides in part that in all criminal prosecutions, the accused shall have the right to be heard by himself and counsel. So Section 13 affords citizens even greater protections than its federal counterparts. Caraway versus State, 819 NE 2D 122 126, Indiana Court of Appeals, 2008. So not only does it guarantee a criminal defendant the right to counsel at any critical stage of the prosecution, but the rights afforded under Section 13 also attach prior to the filings of formal charges against the defendant. Hall versus State, 870 NE 2D 449 460, Indiana Court of Appeals. The court need not speculate whether safekeeping proceedings have serious consequences for the accused. In addition to being moved hours away from his lawyers for over 23 months, Mr. Allen was unconstitutionally kept in solitary confinement in the Indiana Department of Corrections prison and was shackled, leashed, and hooded and deprived of human contact. What's up, Jer? Welcome in, welcome in. See Wolfish versus Bell, which is a violation of the due process for pretrial detainees to be kept in conditions amounting to punishment. As a consequence of that torture, Mr. Allen became psychotic short of his death. It is hard to imagine more serious consequences for Mr. Allen flowing from the November 3rd safekeeping proceedings. Trans denied. Also see Taylor versus State, 689, NE2D, 699, 703, 704, Indiana, 1997, recognizing the right to counsel attaches upon arrest. So Mr. Allen was not afforded either the right to be heard by counsel or by himself at the safekeeping proceeding. This should be particularly disturbing because had he been given the opportunity to do so, Mr. Allen would have had an absolute personal right to refuse the transfer of the department's custody. In either case, accordingly, the court should vacate Mr. Allen's convictions or set this motion for a hearing. So in violation of the due process clause of the 14th Amendment and Nape versus Illinois, 360 U.S. 264 in 1959, and its progeny, the state presented the testimony of Brad Weber. That Mr. Brad Weber arrived home in his white van about 2:30 p.m. on February 13, 2017, either knowing that testimony was false before it was elicited or failing to correct it once it had been elicited. And I'm just so frustrated about this because I have to make this comment. So he was deposed. And Dexter, please stop. I don't need your opinion, sir. I know that. I know you have some things to say. I know you have some things to say about it. Dex. Sorry, guys. Hey, stop, please. Thank you. So anyway, Brad Weber like was deposed and he was questioned by the cops. The first thing they talk about is he gave a statement saying that like he from work he did not go directly home because he had just gotten home from vacation, and he owns those like the ATMs. It's like a service ATM, right? So they're called surge tax ATMs. So somebody like owns an ATM, they put the money in it, somebody goes, they get the money out of it, they stock the money, they make a percentage off of stocking that money, blah, 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 right? So he tells initially when, the FBI and them come like darking his doorstep, he's like, yeah, I wasn't home. I was servicing this ATM, blah, 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 right? And he tells the police at first that he's driving a car. He's driving a car this whole time. Like this whole freaking thing has been, I was driving this car. So he gets deposed. Well, then right before trial, he turns around and he notifies the defense, I had a second thought about this. And I was really thinking about it. And, I wasn't driving my car. I was driving a van that day. Okay. Okay. It's good to see y'all. Good to see y'all. Like, I yeah. A conviction obtained through the use of false evidence known to be such as representatives of the state must fall under the 14th Amendment. The same results obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. Nape versus Illinois 360 U.S. 264, 269, 1953, citations omitted according to Smith versus State 34 NE 3D 1211 1219 Indiana 2015, Shuri versus State 243 NE 3D 1108 1117 Indiana Court of Appeals 2024, trans denied. At trial, the undisputed evidence was that LG's cellular telephone stopped moving at 2:18 p.m. on February 13th, 2017 for 7 minutes until 2:25 p.m. It then started moving again and stopped moving permanently at 2:32 p.m. In closing argument, Mr. McLeland called it a hard fact that LG's phone stopped moving at 2:32 p.m. Hey, Judge Jessica, welcome in. The state introduced an alleged confession by Mr. Allen to Dr. Monica Walla, a psychologist contracted by the Indiana Department of Corrections to treat inmates at Westville Correctional Facility. And in this alleged confession, Dr. Wallace stated that Mr. Allen had said he abducted LG and AW on the south side of the Monon High Bridge and then forced them down the hill to the south side of the Deer Creek. Dr. Wallace said that Mr. Allen said he was on the south side of the Deer Creek and was planning on essaying LG and AW when he was interrupted by a van. Okay. I get what they're trying to do now. Because that's not what he said when he called them people. Because they called me. So, Nick, let's talk about this. So your story was that he had the girls to the site, like the final site. That's the site that they was like caught up at, whatever, right? And you said that he made them like strip and he was going to essay them, but he saw this man off in the distance. Bro, let me ask you a question. In that spot where they were found, that's like a 70, 80 feet drop. Where do you see a main road at? Anywhere. And by the way, like, we know that, like, he saw a van. He never said white van. The color white was, like, added to this entire proverbial of painted, stacked bullshit. And it's really funny because I really appreciated that, it was made sure to be pointed out by these wonderful defense attorneys. that you guys not only recorded Richard Allen, like all times, whether he was in his cell, whether he was coming out of his cell with a camera on him, y'all recorded him at all times. But it just so happened, and I listened to this woman testify about her notes and how they were shredded and all that garbino. Okay, you're a garbino. But it just so happened that when he supposedly made this confession about essaying these girls and seeing this van and all of this jazz that you're trying to sell, that you did actually sell to these people that sat on this jury, you know, that you kept the other information from. You not only did, like, you sold them a dope fiend dream, but you can't even see the eye line of the main road from the spot where the girls were even found. And you can't really see the driveway over at the other crib that's, like, over on the thing. So what are you, like, are you insinuating that, like, it started under the trestle, that he did all of that over there and then decided to take them all the way over across the creek? Either way, even if he killed them and all of that started on the south side, I mean, there are, like, multiple crime scenes here, like, spots. Okay. So are you trying to say that these girls were killed over by under the trestle, under the south side of the bridge, like over near that private drive, whatever, right? And then transported and their bodies dumped over at that spot over there, but you still have a problem? Like, I don't know. I'm frustrated with your story, but I'll keep going. All right. So, hey, Salty, welcome in. Hi, Michelle. Hi, Jen. So yeah, so what I found, you know, again, most compelling is that the attorneys had mentioned that, like, when Rick is apparently making this proclamation of confession, like, this is the only time that Rick is not on video camera the entire time. There's no physical preservation of Monica Wallace's notes. None at all. She said that she shredded them, and she gives, like, a very vague synopsis of the details of the session that had transpired that day. So again, like, the only people that would know really honestly what was said at that given point in time would be Rick and Walla. And if you had a guard, I wonder, because when you describe doing the psychological sessions with him, most of the interactions with Walla were through the door, through, like, the little slit, but, like, she does describe this, like, little, like, 3-inch, like, triangle cage that's, like, in the middle of the thing, and she said that she had a couple sessions with him. I'm guessing that these, you know, confessions happen in that little 3x3 cell or whatever, and it's in the middle of, like, this little this hallway, and the way that they described it was that there were, like, these surrounding pods, and there's a guard out there. And I mean, I don't know really if there's a guard that's on guard, like, all the time, and you're sitting outside and you're having these sessions with this individual. I'm sure that it was probably within earshot of the person that's guarding things, but oh wait, like, he's not going to testify because he's done some incriminating ass shit. Like, they've all done some incriminating ass shit. So look better for you not to bring him up. I'm still processing this. I really am. I'm still processing this. I'm still flabbergasted at, like, the unbelievable list of complicit liars that y'all found to just kick it with you along your narrative path, man. Wow. Anyway, so Mr. Allen said he was on the south side of Deer Creek, and he was planning on essaying LG and AW when he was interrupted by a van. Dr. Wallace said Mr. Allen said he became scared when he saw the van and crossed Deer Creek from south to north, from the Weber property to Ronald Logan's property, taking LG and AW with him. Oh, so you took him over there alive. Okay. but you didn't cross the creek. There's no evidence of them crossing the creek, so find another route. I don't know. Let's see. State also introduced the testimony of Brad Weber that he left work at the Subaru factory in Lafayette, Indiana at 2:02 p.m. on February 13, 2017. And he arrived home in his white cargo van at about 2:30 p.m. From Mr. Weber's testimony, the state argued that Mr. Weber arrived home in his van and was interrupted. With what interrupted Mr. Allen, causing him to take LG and AW across Deer Creek to kill them on Ron Logan's property. The arrival of Mr. Weber's van at 2:30 was a detail only the killer would know, said the state. But the problem is that the state also contended that LG and AW died near in time to 2:32 p.m. When Apple Health data from LG's phone showed that the phone stopped moving, if the arrival of Mr. Weber in his van interrupted Mr. Allen, forcing him across Deer Creek, Mr. Weber would have had to arrive near his parents' house at the end of the private drive before 2:32, when, according to the state, the phone stopped moving and was located on the north side of Deer Creek. In fact, Mr. Weber could not have arrived anywhere on the private drive before 2:54 p.m. on February 13, 2017. His arrival was about 2:30. Could not have been a detail only the killer would know, because it did not happen. The state knew or should have known as much, and the state either elected Mr. Weber's testimony about the time that he arrived home, knowing it was false ahead of time, or failed to correct the testimony once it had been elected. Defendant's Exhibit 3A, as attested by Matthew Hoffman, and Defendant's Exhibit 3 is a video recording made on February 13th, 2017. Hi, Warlion. By a security camera that was in the house at 5998 West County Road, 252 North. The video recording was provided to the defense by the state and has therefore been in the state's possession. The security camera faced northwest, and appears to have recorded continuously. Based on the date and timestamp of the video, it appears that the security camera was set to record date and time information as part of the recording. The time on the security camera was set 12 hours behind, such that 12 a.m. is really 12 p.m. on the same day. This is apparent due to the daylight and moonlight on the video and the associated timestamps. The security camera had a wide-angle lens that captured video of traffic on West 25 or 252 North and County Road North 625 West, and the beginning of the private drive to the Weber property, which begins as a continuation of North 625 West, approximately 190 feet north of that road's intersection with West 252 North. County Roads North 625 West and West 252 North are the only roads by which a vehicle could enter the Weber property. According to that time and date stamps on the security camera recording, Exhibit 3A shows a white vehicle going north on North 625 West, entering the frame at approximately 2:44:33 p.m. on February 17th. Exhibit 3A also shows a white vehicle continuing into the private drive to the Weber property at approximately 2:44:54 p.m. Exhibit 3A is viewable on YouTube at the following address. Exhibit 3B is a video file that contains 3 zoomed clips from the video recording. That is Exhibit 3A. Each successive clip in Exhibit 3B is zoomed to a greater magnification. Exhibit 3 and all 3 zoomed clips of Exhibit 3B, a white cargo van going north on North 625 West just after 2:44:33 p.m. on February 17th, 2017. Exhibit 3B is viewable on YouTube at the following address. Exhibit 3C is a PDF with still photographs taken from Exhibit 3B at each magnification level. Exhibit 3 for each magnification level, zoom level 1, level 2, and zoom level 3. There are 3 skills showing the white cargo van. Just before it passes the white sunlit house in the background on the west side of North 625 West, as it blocks the sunlight or the sunlit house, and just after it passes the sunlit house. Reproduced below is the first still photograph on page 3 of Exhibit 3C, showing circled a white cargo van before it passes the sunlit house on the west side of North 625 West. I'll go through the exhibits separately, like after this, so we can look at them. But Exhibit 3D is a photograph of Brad Weber's white cargo van provided to the defense by the state and therefore has been in the state's possession. The photograph of Mr. Weber's white cargo van in Exhibit 3D appears to be at least similar to the white cargo van as it appears in Exhibit 3B and 3C. The zoomed video clips and zoomed still photographs created from Exhibit 3A, the original security camera recording. Other video files produced by the security camera in the state's possession provided to the defense in discovery and covering the time from 2 p.m. to 4 p.m. on February 13, 2017, do not show any other van driving north on North 625 West into the private drive to the Weber property or traveling east on West 252 North during that time. 30. Exhibits 3A, 3B, 3C reflect that if Mr. Weber returned home in his white cargo van, he could only have arrived home some minutes after 2:54 p.m. on February 13, 2017, 12 minutes after the time the extraction of Libby German's cellular telephone shows that the telephone stopped moving at 2:32 p.m. Either the white cargo van shown in Exhibit 3A, 3B, 3C is Mr. Weber's, with him driving home some minutes after 2:54 p.m. on February 13th, or it's not. In either event, no white cargo van or any other van entered the private drive to the Weber property after 2 p.m. After 2 p.m. and at or before 2:32 p.m. on February 13, 2017. The time the extraction of Liberty German cellular telephone shows the telephone stopped moving. So the defendant's Exhibit 3E is a redacted FBI subject information sheet for Bradley Weber. And it's dated March 3rd, 2017. The unredacted version of Exhibit 3E was provided to the defense by the state and has therefore been in the state's possession. Exhibit 3E, the FBI subject information sheet for Mr. Weber, says on 2/13/2017, Weber's phone pings to his parents' address overlooking the crime scene, initially at 2:50 p.m. And it repeatedly pings around the property until 11:55 p.m. Mr. Weber's phone first pings at his parents' address at 2:50 p.m. on February 13, 2017, and is consistent with the video evidence in Exhibits 3A and 3B and 3C, showing that Mr. Weber could not have arrived home in his white cargo van until sometime after 2:54 p.m. that day. For both Exhibits 3A, the security camera video recording, and Exhibits 3E, the FBI subject information sheet for Mr. Weber, the state either knew that Mr. Weber's testimony about the time of his arrival would be false before it was elected, or they failed to correct it once it had been elected. When the state introduces testimony it knows will be false, or fails to correct testimony it knows and should know to be false, once elected, a conviction must be vacated or reversed if that false evidence may have had an effect on the outcome of the trial. To receive a new trial, the defendant must show that there was false testimony, that the government knew or should have known that it was false, and that there is a likelihood that the false testimony affected the judgment of the jury. To obtain Mr. Allen's convictions, the state explicitly relied on Mr. Weber's testimony about the time he arrived home and used that testimony to corroborate Dr. Walla's rendition of Mr. Allen's statement that he became scared when he saw the white van. When he saw a van, so he took the girls to the north side of the Deer Creek and killed them. This was the only statement allegedly made by Mr. Allen that contained any details of the murders that might be true. Hi, Big JD. The state, therefore, cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have an effect on the outcome of the trial. Alternatively, were the court to find that the state did not know or should not necessarily have known about Exhibit 3A, the security camera video, and Exhibit 3E, the FBI's subject information sheet for Mr. Weber, then both exhibits constitute newly discovered evidence that would probably provide a different result at a new trial. Accordingly, for either reason, the court should either vacate Mr. Allen's conviction or set this motion for a hearing. Number 2, Ron Logan's confession to Richie Davis before May 15, 2017 is newly discovered evidence entitling Mr. Allen to a new trial. Dr. Kaur was the forensic pathologist who conducted the autopsies of Liberty German and Abigail Williams. His original opinion held for years about how Liberty German and Abigail Williams died, what that two weapons were used, one a serrated blade and the other a straight-edged blade. For the first time at trial, having a eureka moment at his tool bench, Dr. Kaur opened that the girls could have been killed by a single box cutter rather than 2 different knives. Defendant's Exhibit 4A, as attested to by Matthew Hoffman in Defendant's Exhibit 4, is a redacted copy of a tip from the Orion database of the tips dated May 15th, 2017. In that tip, the state has always had Ron Logan is alleged to have confessed to Richie Davis sometime before May 15, 2017, while they were in prison together, that he killed LG and AW. The material part of Ron Logan's confession to Richie Davis, as it appears in Exhibit 4A, is reproduced below. So Logan confessed to Ricky step by step of killing the 2 girls. Logan told Ricky how he burned his clothes at a fire pit and where it was located, used box cutters, and struggled with one of the girls and thought drops of blood from his nose ended up on her clothes. I hope she socked your ass in the nose real good. Ricky also advised that he killed the older girl first. Mr. Allen also said that he shot the girls in the back and buried them in a shallow grave. Neither of the girls were shot in the back. Neither were buried in a shallow grave. Ron Logan's confession to Richie Davis, as reflected in the tips in the Orion database and made a mere 3 months after the girls were killed, was detailed. Law enforcement followed up on the tip. Defendant's Exhibit 4B, as attested to by Matt Hoffman in Exhibit 4, accurately reproduces the handwritten notes taken by the Indiana State Police First Sergeant P. Hansard about his interview with Ricky. I don't know why I keep saying Ricky Davis on June 21st, 2017 at the Newcastle Correctional Facility regarding Ron Logan's confession to Richie Davis. Those handwritten notes of First Sergeant Hansard are attached to Indiana State Police Detective North Wolf's lead narrative summary cover sheet as it was provided to the defense in discovery. First Sergeant Hansard's notes of his interview with Richie Davis about Ron Logan's confessions provided even more details. Hard as they are to decipher, the subject to debate and correction, those notes reveal the following about Ron Logan's confession to Richie Davis. Page 1 of Exhibit 4B is reproduced below. It seems to say, talking about knowing one of their dads, to walk with them. One of them wanted to turn around, grab the youngest shoulder. It's okay. Oldest freaked out. One said something about calling the police. SA attack was not true. Originally not trying to R them. Paranoid about probation. Felt like he crossed the line when he grabbed the youngest one. The top half of page 2 of Exhibit 4B is reproduced below. The bottom half of the page duplicates the top half. It seems to say, so I have it, but let me see. Which exhibit is that? It's 4B. I'm pretty good at reading Chicken Scratch. So it'll do its thing. Okay, I'll just, I don't know what it's doing. Anyway, so it seems to say that he started talking. Ironic, should have been in school. Oh, there it is. Okay. So he was walking. Let's see. I'm going to do this. Presents. Okay, so he's walking and talking about knowing one of their dads. Something about walk with him and one of the moms. One of them wanted to turn back around. He grabbed the youngest shoulder and said that it was okay. The oldest freaked out. He got paranoid and he grabbed her. One said something about calling the police. SA wasn't true. Originally not trying to. So, he wasn't originally trying to R them. He's paranoid about his probation and he felt like he crossed the line when he grabbed the youngest. He started talking, ironic, should have been in school, talking to them, that he knew one of their moms worked at a bar, talking to them about animals, walked with them, asking if they were willing to go check out horses. And he said he told them he had rabbits in the barn, that he walked through the trails. They had walked through the trails, in the weeks or whatever. The oldest was paranoid, and did not want to go to his house. The youngest definitely wanted to see the horses. He started telling, why is it okay? He started telling, ironic, should have been in school, talking to them, knew one of their moms, worked at the bar, animals walked to them, willing to check out the horses. He says he told them he had rabbits in the barn, walked through the trail in, something. Oldest paranoid, warning, youngest wanted to see the horses. The oldest tried to help the youngest. Oldest started talking. The youngest, something. Scared. something. I don't know. So he now grabbed the oldest and said that he got hit on the nose. Something because he now grabs the oldest. He said he got hit on the nose. Something got, oh, but he was scared. He got blood of one of the girls. He was scared he got blood on one of the girls. So he pulled out a box cutter and slit the oldest one. And then he hit an artery. The youngest was scared. Took little something him for a while, never said where. Oh, so he took the youngest girl. So he took Abby somewhere else for a while, but he never said where. That's what that says. He said he cut her to cut both necks. He left again. Oh, shit. He left again, come back a little later in the evening, and the search was going on. Something late hours, tried to move the oldest one to the area. Not going to be hard. The place where he lives, there are four-wheelers around. You can go burn the clothes in the burn pile. And the gloves and, blah, 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 the boots. Could something of boots be, could soles of boots be burned in, or be left in, I don't know, left in the burn pile, I guess, maybe. So the next morning, two other girls, what is that word? Son of a biscuit eater, what is that word? Oh, two girls knocked on the door and asked to search on property. Something, feels something, and he said no. What? Okay, so he let them take off, got a hold of a family member, got out of whatever. The first time he's seen them from property, what was that? Horse? Something about guns? Driving, struggle, youngest girl, should not, I don't know. Jeez Louise. Yeah. Sorry, y'all. I'm trying to decipher this because, this mess. Hard talk. Something Abby. So I don't know what in the world that little mathematic shit here is about right now, and I don't give a fuck what it's about at the moment. So 3 months from Pendleton. He got here 2 months in 4-pod dorm. Originally in the rec line together. He wanted to set up a JPay account that, to help him out. He started talking uncomfortable circumstances, possibly talking about it, beginning modifying county charges, etc. Oh, yeah, I remember that, looking at his stuff. because they weren't sure what time he left digital. That's why, because so his phone pinged that day. There was a ping to like the area, like on his property. They said in a round about like where the location was of where the girls were taken, or not taken, but where they were found. There was a ping to his phone. It was at two. I want to say it was 2:19 p.m. or whatever. Where 2:09. It was 2:09 or 2:19 p.m. 2:09, I think it was. I want to say it was 2:09. So he was at that spot, and then it says, this was I found that information because you have the Ronald Logan search warrant. It's stuff there, but I was reading the Susan Hendricks book, her Delphi descent stuff, and she talks about it. So there's another interesting like ordeal about the phone. So we know that the phone jack on the phone had that piece that was plugged in at like 5:30 something, right? And it was disconnected at like 10 something. Ron Logan has some sort of text message. I gotta go. I can go grab the book. Anyway, there's a text message that comes in on Ron Logan's phone that he receives like 10 something p.m. So you got to think about this. Like there's that time where he receives his text is communication. It's not a call, it's a text. Again, they're saying that it's within the location of where the girls' bodies are dumped. And then somebody unplugs that item out of the phone at like 10, was it 10:32, 10, whatever. I'll have to go back and look anyway, but you understand what I'm saying. So like it correlates right down the line. They want to drop a time here and there about cell data to fit the narrative. Yes, digital. Yes, they do. So that's all I'm saying. Like there's so much going on here. Like I'm so irritated the more and more that I look at this and the more and more that I see. And I also have to take into account now. So we have Ron Logan. This is a confession from Ron Logan. They said we have a confession from Richard Allen. They have somewhat of a confession from Keegan Klein. What were they doing? Like going down the line and collecting confessions, and if it wasn't going to work, they were just going to like discard that little confession here, discard that little confession there. Like, you know what I mean? Yes. Thank you. Thank you, Monty. Okay. So, he got the text message at 10:16 p.m. and the headphones were unplugged from Libby's phone at 10:32 p.m. So, yeah. And then like the next morning when Libby's phone turns back on and receives 14 of the 15 messages that were sent to her phone. Okay. That 4:30, Mike Patty was doing a interview with the news literally at 4:30 a.m. And we know that the phone turns back on at 4:33 a.m. I'm not saying that it's like family members. Like when I say that, like that's not what I'm saying. Like yesterday, I think I don't know. When I was mad the other day, I think maybe it might have been misconstrued for some other stuff. But all I'm saying is that there are too many different coincidences that tie back to people that are very close in proximity. And I just have to say, like, sometimes the worst things to happen to people happen in their own backyard. Think about that. Like you see child abductions and things like that. Sometimes the worst things happen in your own backyard. So, yeah. Anyway, so let's see the first mail. And I wonder if they made everybody like write a confession just in case. Like, if you piss me off, I got this. So keep your mouth shut. I wouldn't be surprised at this point. I really wouldn't. I would not. So, um, so talking about it at the beginning, modifying his county charges, um, walking something, first male, losing weight, film, first male comment, losing weight, film footage, etc. That don't look like me. Started talking to his monkey, different scenarios about drinking on probation that day. And he came home and he went out and he said he's seen the girls and he had 2 different encounters, several. So something shook up. Is that shook up? Sock up? Walk in, came back from the rabbits, changing from wild rabbits to squirrels. It's fucking disturbing. Anyway, so I'm going to switch back over to this other one. No, like it wasn't the spot that they were at where he did that that interview. Like it wasn't like super far, but it wasn't super close by. Like I've been there, you know what I mean? Uh, I recognize that spot, like walking around that spot out there. I recognize the spot. Like if I went out there, I could show you the exact spot of where he was at doing that particular interview. But he wasn't super duper far away. You know, he wasn't so far that nobody would have heard nothing. I just, ooh, mm-mm, mm-mm, no. Like frustrated. Like I'm so frustrated with all of this. I really am. Um, So it seems to say he started talking ironic, should have been in school, knew one of their moms, waitress at the bar, animals, walk with him, going to check out the horses. Um, he told them that he had rabbits in the barn. He walked through the trail in the woods. Oldest was paranoid and did not want to go, and the youngest wanted to see the horses. Um, and it says the top half of page 3 of Exhibit 4B is reproduced below. It seems to say the oldest turned to the youngest to help the youngest. The oldest started kicking. Youngest seemed he now grabs the oldest. He said he got hit on the nose, scared, got blood on one of the girls, pulled out a box cutter, slit the oldest one, and hit an artery. The youngest one was scared. He took the little girl with him for a while and never said where. And he said he cut to both necks. So again, this is the bottom half of page 3 of Exhibit 4B. It seems to say he left again, came back later in the evening, search going on. Later on, late hours, tried to move oldest one to area not going to be found. Place where 4-wheelers go, burned his clothes in a burn pile, hiking, walking, boots, gloves, bags. The top half of page 4 of the Exhibit 4B is reproduced below. It seems to say soles of boots. He blank and burn pile. Next morning, 2 other girls knocked on the door and asked to search on the property. Filled word if he said no, so he let them take off. Got a hold of a family member and got out of the area. And that's where he called his cousin, David Nolf. That's when he, wanted to help him recreate the alibi. And the guy lied to him the first time he talked to the FBI, but then he went back to the FBI to talk to him again. And he was like, yo, bro, I can't even lie to you. I got to tell you, like, this is what's up. So the FBI was like, all right, well, thank you. Thank you so much. Thank you for telling us. And I got left with that, right? So Riley did say Sugar Creek. That was the first thing he said was Sugar Creek. instead of Deer Creek or whatever creek. So, I don't know if anybody had to necessarily rent out a canoe. I mean, there was a place nearby that you could rent canoes. It's not unheard of in the area. But also, I'm sure that many of their friends over there and the properties surrounding them, there's people that own canoes over there, right on the water too. Who wouldn't help a friend out in town who had a missing family member and needed to scour the water? You know what I mean? You know, don't you, Aaron? I do. Anyway, um, so it says the bottom half of page 4, Exhibit 4B is reproduced below. It seems to see the first time he sees them from the property, home, etc., guns, etc. During the struggle, the youngest girl not happen to a friend, stand there, head, neck artery. Defendant's Exhibit 4C is a handwritten note signed by Richie Davis, dated June 21st, 2017, the same day First Sergeant Hansard interviewed him. That handwritten note is attached to the same lead narrative summary cover sheet and is contained in some of the files as First Sergeant Hansard's written notes are Exhibit 4B, Exhibit 4. Richie Davis' handwritten note about Ron Logan's confession to him says, Mr. Logan has made reference to killings in Delphi, Indiana. He told me he was the one who killed those girls, that it got out of hand. He walked with them in the woods to his property, and the girls wanted to turn back. Said something about walking the blank, probably the dog. He grabbed the youngest girl to reassure her that it was okay. However, they panicked, and he also panicked. He indicated he ended up cutting the oldest with a box cutter. He went on telling me that he killed both of them because it took too far. So, in addition to the other details that fit the known facts, Ron Logan confessed to Richie Davis that he used box cutters to kill the girls. If instead of for the first time at Mr. Allen's trial, Dr. Kors said 7 years earlier, said the girls could have been killed by a box cutter, there would have certainly been probable cause to arrest and charge Ron Logan with the girls' murders. And as it was, the FBI, 2 months before Ron Logan's confession to Richie Davis, had obtained a judicial finding of probable cause to search Ron Logan's property. Under the circumstances, Dr. Kors' trial testimony about a box cutter possibly being used to murder the girls makes Ron Logan's confession to Richie Davis newly discovered evidence that would either be admissible through Richie Davis, according to the Indiana Rules of Evidence 804B3, or through the First Sergeant Hansard under the Due Process Clause of the 14th Amendment. Ron Logan's confessions exculpates Mr. Allen and would probably produce a different result at retrial. Accordingly, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. Number 3, Defendant's Exhibit 5, the affidavit of Stacey Aldridge, states that dirt or water damage to the phone could have caused the auxiliary jack on LG's phone to log-wired headphones plugged in and wired headphones unplugged. Miss Eldridge expert opinion is newly discovered evidence that would probably produce a different result at a new trial. Oh my. At trial, Mr. Allen introduced evidence through the testimony of Stacey Eldridge, a digital and mobile forensics expert, that someone plugged wired headphones into the auxiliary jack of Liberty German's phone at 5:44 p.m. on February 13, 2017, and unplugged it at 10:32 p.m. the same day. Oh, I was off by like an hour or whatever, I think. I think I said 4. I don't think I said 5, but either way, you guys know. So to counter this, the state offered the results of the seat of the pants Google search by First Sergeant Cecil, the state's phone expert. According to First Sergeant Cecil, the Google hearsay told him In his expert opinion, the log on LG's phone showing wired headphones were plugged into the auxiliary jack at 5:44 p.m. on February 13, 2017, and unplugged at 2:32 p.m. that same day could have been caused by dirt or water damage to Liberty German's cell phone. The defense had no opportunity to counter First Sergeant Cecil's expert opinion, courtesy of Google. The court should read this, Miss Eldridge's affidavit, Exhibit 5, in its entirety, but the short version of Miss Eldridge's actual expert opinion is nothing in the data on Liberty German's phone indicated that there had been water damage. None of the reports or extractions related to Liberty German's phone created by law enforcement reflected dirt or water damage to the phone. Photographs of LG's phone taken by the Indiana State Police did not show the phone to be wet, dirty, or covered by debris. Ms. Eldridge is unaware of any scientific or technological research suggesting that water or dirt damage to an iPhone 6 would cause the phone to inaccurately log wired headphones in or wired headphones out. According to the Apple Health data on Liberty German's iPhone 6S, the phone stopped moving at 2:32 p.m. on February 13, 2017. At trial, the state contended that Liberty German and Abby Williams died close to that time, and Abby Williams hid the phone under her body before she died. The state also provided testimony by former police chief Steve Mullen and Indiana State Police Lieutenant Jerry Holman. There was no evidence that Mr. Allen returned to the location where the bodies were found after allegedly being spotted by Sarah Carbaugh on County Road 300 North at approximately 3:50 p.m. on February 13, 2017. If Miss Eldridge's actual expert opinion that wired headphones were plugged into LG's auxiliary port at 5:44 p.m. on February 13, 2017 and unplugged almost 5 hours later were credited by a jury, the state's narrative is impossible. Someone other than Richard Allen was handling Liberty German's phone multiple times long after the state contended Mr. Allen left the scene before 4 p.m. on February 13th, 2017. Excuse me, I'm sorry. Miss Eldridge's opinion, my bad, that dirt or water could not have caused Liberty German's phone to log wired headphones being plugged into and being unplugged from the phone on February 13, 2017 exculpates Mr. Allen and would probably produce a different result at a new trial. Accordingly, the court should either vacate Mr. Allen's conviction or set this motion for a hearing. This matter, set out and attested to above, taken individually or cumulatively, entitle Mr. Allen either to have his convictions vacated or to have a hearing on those set matters. Conclusion. For the foregoing reasons, Mr. Allen respectfully requests that the court either vacate his conviction or set the matter above for hearing and for all other and just proper relief in the premises. So that was fun. So I guess, I don't know, maybe we should go through exhibits. I believe a video, like an interview, like evidence of a video interview should be able to be used to impeach a witness. If they're lying, yeah, it should be. But I don't know. I guess maybe that's why, like, if the witness were to come back and say, hey, like, I've had a change of mind or whatever, that's okay. Like, if I guess maybe if the witness comes back and says, hey, like, I've had another thought or I remembered this. But the problem that they didn't do is they were supposed to go back in and correct the record and say, okay, the witness came back and corrected the record and said, I wasn't driving a vehicle, I was driving a van. You know what I mean? So they did not do the follow through with correcting that record and updating that record if that was the case, or they knew that that wasn't true and Nick didn't want to risk his law license putting it on a document. You know what I mean? Or, yeah. And just put him on the stand and said, fuck it, go with it. Because he didn't think that it was going to be a big deal. Like, they had gotten away with so much anyway. So, I'm going to go through comments. And there were a couple of things that I had, kind of noted with all of this. But yeah, so many things to keep, like, mulling over, you know what I mean? Just kind of like as a totality, because, you think about connections. I mean, the Anthony shots, Ron Logan having the connection to not just Brad Holder, but Tony Klein, and it's a bunch of painted, like, narrative and subliminal messaging with this crap. Again, you have people that were there that weren't asked to testify, people that, didn't want to lie, so they weren't called. The evidence, the destruction of evidence, the prosecutor and the judge don't want to preserve the evidence that's there. And they are talking about, oh my God, other devices and belts and cigarette butts and all of these things. And the more and more that I am, like, getting through and I'm reading stuff, and I'm just, there are so many things wrong. So many. It's insane. Insane. Okay, so if Ron Logan had his phone with him when he went to Lafayette, why did they have to use the receipt from the fish store to determine where he was? That's a really good question, Digital. Maybe that's something that we can ask Christine, because she'll be coming back for another another rap session or whatever. So I'll be sure for her to for us to ask her. And I'm thinking, like, I enjoyed the format that of interaction that Prof was having last night with Christine. Like, I think they did a fantastic job. I was so excited to watch that and just hear some more, but it was really nice to be able to just relax and listen, so maybe I'll see how she feels about the call-in section or whatever. I literally said for almost 3 years the attack happened under the Southside attack. I specifically mentioned Jerry. I'm not guilty. Right. Exactly. And you've been screaming it. Yeah, you're right. You have been screaming it for a long time. Aaron, sorry to be very late, but you know where I was. Yes, I do. But thank you for saying I'm still absolutely the best woman. Hi, wifey. Polygraph. Been driving home. Digital says. Woman, she says, say box cutter one more time, right? I'm about to jab out if I hear box cutter one more time. Going down. I could be wrong, but I think some are saying that math is results from the inmate's polygraph. Oh yeah, I remember that polygraph rat's ass bullshit. Listen, I don't understand how people who are not dealing with the documents for themselves are able to explain to you what that whole situation is in full, or how it worked, whatever. Because, like, aren't these the same people that are talking to the lying liars? So why would I believe anything that the lying liar has to say out of their mouth? I don't give a fuck if you went to a damn clerk's office and printed it out for yourself. You called to get your explanation from somebody who is just not, they're not credible. They're not trustworthy to me. And because they're connected to so many uncredible and grimy fucking people, I wouldn't trust a motherfucker that was connected to either one of them to call and ask a question. Hell no, I ain't gonna phone one of their friends. Here, let me phone a friend and ask them what they think of their bullshit. No. They're gonna be like, tell that bitch it is what it is, just like this. Tell her, roll with it. And you walk around thinking that you got the right information until you finally get, well, some of these people, okay, some of these people do not take their head out of their behinds, and they do not look things up for themselves. They do not explore. They take somebody else's word for it, and that's fine. That's great, I guess, for them. Because again, I don't want to tell somebody else what to think. You can go and look for it and find it, you know. It just amazes me how many people will walk blindly. They will walk by sight of somebody else. They won't go dig for the information themselves. And then they will come and try to tell you what the information is from, yeah, never mind. Shut up. Shut up, pretty. Don't be mean. Anyway, family meet. Aaron says family could mean descendants of one of the pioneers, thus literally related by blood, or it could mean loyal to a brotherhood, sisterhood, gang, or other groups, or both. Yep. Bingo, bingo, bingo. Okay. So yeah, Riley did say Sugar Creek. Aaron says upstream to get canoe, downstream to the Chevy by the levee at Riley. That's what friends are for. Yep, exactly. Ooh, and there's like, okay, so there's that little group of like the cabin stuff over there too. Like not like Riley Park or whatever. Well, there's some cabins like there at Riley Park, but there's another section of town. It was like it's another park, but it's like got a bunch of like cabins and stuff over there. But it's tucked back. Like there's a bunch of like houses all like clustered together. You know what I mean? And you take like this little side road and it's over there. But I don't know. I remember when I got lost in the area the first time that we went and got stuck in that area. And I was like freaked out when I saw all of those like little cabins there and it was tucked away. Incidentally, oh, do you guys remember, do you remember the article that came out like maybe a couple months ago about the guy who was in Delphi? Apparently he had been talking to a young lady on social media. And he had, set up to meet with her to go smoke some tree and got caught up. There was a picture where it showed like cabins and it showed like some water and stuff like that, right? That's where I'm talking about. Like there was a photo, like it was just like a photo to look at. I don't know. Anyway. Hi, nobody, nothing. Hi, digital. So yeah. If I remember correctly, was the Alexis that no longer bears the last name. This mistook for Snowburger. So probably WTHR or whatever the correct letters are. Yeah, maybe. I don't know. Oh, Alexis. Did she leave that network? Or was she with RTV6? Alexis McAdam. I want to see if she was with RTV6. She may have went over. I don't know. Anyway, so there's that. And just, yeah, there's so much more. So if you guys want, the format with Christine, the same way that, they did it yesterday. We can do that, or we can do it by text or whatever. I mean, I think it might be easier to have an open panel because it would give us a easier way to have like a more generalized conversation flow. I prefer it that way personally. So I could ask her and see how she feels about that. You're welcome. She just texted me and said, "Ooh, thanks." All right, you're welcome. So if you're down for it, let me know or whatever. But all right, guys, I'm going to go ahead and I'm going to get out of here. This is the document read for the motion to correct error. I will get something set up for us to have a chill day or a chill night, and then we'll start diving into other topics, I think, that go with this case. We're going to, I want to start sectioning it off and discussing certain stuff. So, all right. Thank you guys for coming. Don't forget to like, share, subscribe. Have a blessed and beautiful day. Bye.